I want to talk a little bit about the statement of information. What can you add to tell us, to give us a sense of how that format was selected as a way of presenting this information to the committee?
Well, the last comment I made was to underscore his determination to avoid any form of partisanship. And you can tell from the title, Statement of Information, how that's consistent with the purpose. I mean, there's never been a document before in the history of these proceedings called Statement of Information. What he wanted was a statement of information, not a brief or anything near a brief. And so he presented it as a kind of dry, methodological, impeccable, distillationable, the information. That was the tone that we kept throughout. If you'll recall, one of the members of the Judiciary Committee, when John read it, remember he read he said, John Doerr couldn't put us to sleep even if we're reading The Happy Hooker. And I mean, he was at his most, Midwestern, Republican qualities of just dryly reading fact by fact without trying to give any sort of sense of drama or mystery unfolding or any tinge of advocacy.
I've read.
This one thing you have to understand. This is how he ran the Civil Rights Division. The Civil Rights Division, begins its operation in the late 50s, but really takes off over the early 60s. This is an extremely divisive, explosive issue in American politics, and he believed it was necessary, if we're going to make any progress on civil rights issues, that he had to present this matter in a kind of elaborate, factual presentation. And that was his signature in the Civil Rights Division. Many of the judges who later became heroes of the civil rights began with great skepticism of these civil rights. These people, Judge Johnson, Judge Wisdom, Judge Brown, were all parts of the society that was being criticized and attacked during that period. And John developed a mode of operating which just consisted of the dry presentation of facts. You can't get a grasp of John by looking, I don't think, at the Neshoba trial, which is kind of dramatic and nation-attendant. But John's real contribution was the development of these facts in the early voting cases before the Civil Voting Rights Act of '65, school desegregation cases, where the presentation was just like, these are the number of students, these are the school buildings, these are when they're built, these are the teachers, the salaries, this is what happened, this is the fact. And, I mean, his emphasis during the Civil Rights Division was almost like treating these cases like antitrust cases. I mean, not as a kind of criminal case with a human interest story. And he operated the division to always put the emphasis upon the facts, facts, facts. And when he became the chief counsel of the impeachment inquiry, he had the same model. And I was not present when he chose the top title Statement of Information. I wasn't in on that discussion. I don't know who on the division, who in the staff made it or recommended it. But when I came and saw that this is what it's going to be called, I smiled. I mean, this was like so John. And that's basically how it would evolve.
Do you think he was a little disappointed that the committee member needed a little bit of tutoring? I understand that Dick Cates used to give them little seminars on how to. There were some. I've read there were some complaints from the committee members. They were having a hard time absorbing these statements of information. Do you remember that at all?
I have a vague recollection of it, and I mean, this was like, I mean, it's not easy to be a judge in an antitrust case, reading volumes of volumes of information about economic performance, and this was the same thing, just go on and on. But he didn't shake from that. He didn't move from that. Yeah.
At what point do you think he shifts from being someone who's assembling material to actually being a prosecutor? When do you think he made up his mind about impeachment? I guess that's what better way to put it.
I think it was pretty late into I think he had made up his mind. I mean, I'm not sure about which articles and all the rest, but I think by the time I mean, he had been seeing drafts of statements of information, and I think as that began to sort of assemble, I think he made up his mind at that point. I think it was late in the process. How late I can't recall specifically, but it did not come quickly or easily.
Well,
I think also remember, you keep in mind, presidential politics are changing during this period. I mean, he's not even quite sure. We're not sure of the outcome at all. I remember, I think Nixon makes a trip abroad in July?
yes.
And returns home extremely popular and successful. Doesn't know it's not clear what's going to happen in terms of the committee, what the committee would do. It doesn't. I think what happened was he turned home very popular, and then the impeachment inquiry released the retranscribed tapes, and that sort of pushed back on the public reaction to his trip abroad.
Why did the committee not wait for the Supreme Court decision on the other tapes? Because of course the smoking gun tape doesn't come out until after the Judiciary Committee has voted on these articles. Was there any thought to waiting until Jaworski and Sirica's case had been adjudicated by the Supreme Court to get it?
I don't remember any discussion about waiting at all. I don't know if we knew what was on those 18.5 minutes and stuff, or.
Well, that nobody does.
No, but I mean, or didn't they were projection? There must have been some consideration at some point, but I think once the impeachment inquiry was authorized, I just think there was a kind of momentum that ran on an independent track, and it wasn't about to be. It wasn't. I don't remember any discussions, although I'm sure they must have had them.
Did he ever?
I mean, the decision when it came down was an incredible historic moment, and I remember having dinner with him that night, and then going back to the office late at night, and one or two congressmen were coming by to look at sort of information or what. I don't know why they were sort of, but I mean, it was an incredibly dramatic turning point in American history, and this whole proceeding. Sometimes, when a lawyer gets involved in a case, a prosecutor, or it could be a plaintiff's lawyer, defendant's lawyer, they get somewhat disappointed when there's a settlement. Like, why can't we go through to, I'm all prepared to go, why are you pleading guilty, or something like that. But there wasn't any feeling on John's part about that. I mean, I think when the news came down, it was, you know, we did our job and we did it well, and this only confirms what we were doing, really.
For people watching who are not experts in the whole issue of impeachment, since you did not know that the story would end with the president resigning, was it anticipated that these statements of information would actually go to the entire House after the committee voted and approved what articles? In this case,
well,
3
it's
articles.
very unclear what the trial in the Senate would consist of. You know, it's conceivable. It was conceivable that it would be based on that, but I'm sure the president would want a kind of independent fact. I mean, we're talking now about multiple levels of hearsay, and the Senate would like probably to have sort of independent, but it wasn't looking ahead to that. I mean, it was really, I mean, I don't know. Our minds never really turned to the Senate trial, really.
Well, I was also thinking
it was such an extraordinary moment. I mean,
what about the House? The House still had to vote, right?
Yeah.
In the House.
Oh, I'm sorry. I thought you were talking about the Senate.
I was going to get to the Senate.
I'm sorry.
That's okay.
I think they assumed that the House would be acting on the basis of the statement of information and the action of the committee. That would go. That would be the factual predicate for the deliberations of the House of Representatives. I mean, that was an operative assumption. I don't recall any specific conversation, but we all assume that.
Now, do you remember the discussions about what role the president's counsel would play in sort of rebutting these statements before the committee vote? I'm still talking about the House Judiciary Committee. So, of course, there was a bit of a controversy as to how much time would St. Clair have? Would he be able to actually cross-examine people? That sort of thing. Do you recall the issues that arose?
No. I mean, we discussed it, but I don't have a very clear recollection. When you're writing something like this, you're always imagining what they would say. I mean, you can't write an effective legal document or even political document in a kind of context like this unless, I mean, every time I worked on it and I had like one iota of information, I tried to imagine what someone who would be defending the president would say about it. So I constantly imagined what it is, what they would say, but I don't remember conversations about, you know, what should St. Clair be able to do before the committee, et cetera. I don't recall that.
And I suspect you don't believe that they are hermetically sealed, but how intertwined were legal and political issues here? You were saying both. As you put it, it's both a legal and a political document. Was this a legal process?
Well, when the Statement of Information was released, there was a column in the New Republic saying, this is the most powerful political document ever produced in American history. And I kind of smiled because I thought it was just pure law. There was nothing political about it. I mean, John was always aware of the political milieu in which we operated, or he operated. He was always then. But I think he really saw himself all the time as a lawyer. He certainly didn't let the staff have much input on politics. I would never talk to him about politics or any aspect. When I say politics, like what would this congressman's reaction be, or that congressman? I mean, we'd have chit chat, but I had, you know, I had no intelligence about politics, and I try to just do it as a lawyer. It has tremendously profound political implication. I think that's what New Republican meant. It becomes vulnerable to political dynamics. After all, the Congress people are politicians and subject to that. but that was always kind of another world.
But you knew that, I mean, you, as you said, you understood the implications of what you were doing.
Yeah, absolutely.
So, and you were still in your 20s. Well, how old were you then?
I was in my early 30s.
Early 30s.
Early
It must have
30s.
been pretty heady. Must have been a heady time then. Busy, I know. You were, but
it was heady, and you know, you needed to believe in what you were doing to work 2 or 3 nights without sleep or something like that. It was very, very, very heady. My own personal feeling was, gee, I'd like to be back in Washington or Chicago getting ready for my classes or something like that. What am I doing here? It was, you know, it was just a norm. I mean, I had a very, I'm sure I'm naive, and but I had a very technocratic aspect to it. I was being a lawyer. I was helping out in this inquiry. I didn't have intelligence about the rest of the political setting and stuff like that, and I just put my head down and worked.
When, just on a sort of a technical, to discuss a technical issue, when you would work on a statement of information regarding, let's say, abuse of power, would you then go and talk to Robert Sack, later Judge Sack, about, because since he compiled a lot of the material that went into that, would you have talked to him when you were editing it, or was it beyond him at that point that you...
It was really beyond him. I mean, I would talk to him, and he was friendly and smart and all the rest, and some things I didn't understand, but it was like beyond him.
Do you remember?
Now, John
Yeah.
would have conversations with him. I mean, it was not, see, it wasn't like, here's Judge Sachs, and here I am, and here John. I just worked for John. And John had doubts about what I did, a lot of times, I'm sure. And John would probably go up, I mean, it would go up to John. It would go to John, and then John would take it up with Bob Sack.
Okay.
Or someone else. Believe me, you know, my word was not the last word. John was the last word.
Do you remember?
And he consulted even things, he might have discussed it with Burke Marshall, or he might have discussed it with Bob Owen, or the official staff. I mean, we were like sort of shadow people, you know. We were like his sort of special staff. And they knew it. I'm sure a lot of them resented outdoing it, but I'm not looking at that from Bob Sack. But John would go back to him. John would be respectful of his position. John would go back to Bernie Nussbaum or something like that. John was very respectful of the position, but it went not from me to them.
So
but
okay. You're like a kitchen cabinet.
Yeah.
So it was you and Burke Marshall. Was there anybody else who was sort of a special advisor to him?
Well, Bob Owen operated in
Yes.
that way. Dorothy operated in that. I mean, the three of us often were in the same room. And of course, you probably know about Renata Adler was a person that was involved as a kitchen cabinet, not on a daily basis, but she was involved.
She would write quite a critical piece in The Atlantic afterwards.
Yes, well, that's Renata. But she played a very important role. I think it was her, I hope I'm not speaking out of school on this, but I think it was her intuition when the transcripts were released that there's something funny about the transcription of these recordings. And that was based, she's an extraordinary writer, but she felt that this is not how people speak. There's something, the cadence, everything isn't making sense.
You mean when the White House?
When the White House released the
it.
transcript, it was embraced by the public and sort of more or less accepted until the impeachment inquiry reissued, retranscribed. But I think it was basically her intuition that this is not the way people ordinarily speak, that there's more on these tapes than we get from this transcript.
Oh. So that may be what prompted or helped prompt Mr. Dorr to go ahead
Yes.
and
Yes.
and
Yes.
do your own transcripts.
Yes, yes.
That's, as you said, that was a very significant decision, and it was one
Incredibly.
area where the
Incredibly significant, really. Incredibly significant. As I told you, first, not just because of the impact on politics when it was when the job was done and released, but also in the writing the statement of information. You know, you had a clearer picture of what was happening in these conversations.
How was the decision made to interview? There were, I believe, 8 or 9 people interviewed by the committee, Colson, Kalmbach, a few others. How was that decision made to have them testify?
I don't know.
You don't.
I was back in New Haven, Connecticut, and staying at a friend's house, watching on TV.
What other issues do you recall being very significant and being sort of the center of your discussions with Mr. Dorr as one of his, as part of his kitchen cabinet that we might not have touched on?
Nothing comes to mind. I think it touched on a lot.
Where
I don't remember. I may recall later, but I haven't.
What did you learn as a result of this process?
I would say that the major thing that I mean, of course, my admiration for John grew, but I would say the major thing that I got from the process was we had to confront one of the awkwardnesses of the presidential system of government. It was just too hard, just to impeach. You know, we have the presidential system means that the president has an independent mandate from the populace as well as the Congress, as opposed to a parliamentary system. And I just felt that we just had too high a standard for impeachment. I mean, I think it's integral to a presidential system, but that you have to prove high crimes and misdemeanors is a little bit too rigid and too inflexible. I never perceived that it would be so hard to do. As I said, I don't believe to this day that it requires proof of a crime, in the sense of a violation of Title 18, but it does have some crime-like qualities to it. And I did not believe that the bombing of Cambodia was a ground of impeachment. I had doubts about that. I'm not sure. It shouldn't be a grounds for removing the president. I mean, I just think it's too rigid. When things get that bad, you should be able to remove the president or have another election, or in the way that you have in a parliamentary system. Now, there's many disadvantages to the parliamentary system. I'm not carrying a brief for it, but maybe you could have the presidential system with a lower threshold for grounds of impeachment than the Constitution gave us. That was the major takeaway, I would say.
Well, but then you'd have these confidence motions, right? And if the president lost the confidence of Congress, then they would be removed.
Well, I would say that even if you start, that would take us to the parliamentary system. I'm not recommending that, but I'm wondering, I don't come away to clear conviction, but I'm wondering whether you could have a presidential system with a lower standard than high crimes and misdemeanor gave us.
Do you think that partly this
could be, systematic deception of the public. That strikes me like a good ground of impeachment, of systematically misleading Congress and the public, lying or something like that. I don't think it's a crime, and I don't think it would be a high crime and misdemeanor, but maybe that should be a sufficient grounds of what's going on. I mean, the question, what I came away from is whether you could have a presidential system with a lower standard for impeachment that would still keep us as a presidential system.
Well, as you know, the framers had that whole discussion about it.
Right.
Where were you, and what do you recall of learning that President Nixon was resigning? Where were you when you heard that? I was in Washington. I learned it. I was at the offices of the impeachment inquiry. The Supreme Court's decision came out sometime on, was it a Thursday? I don't remember. It came out, and then we had dinner together, and then I went back to the division. I went back to the offices that night, and then the next morning, and then I think sometime during that day, it was revealed to me. Although that's I asked you about when the president resigned. You've talked about the Supreme Court decision. There's actually a lag between the Supreme Court decision and the president's resignation. He doesn't resign until after the smoking gun transcript is released on the 5th of August, and then he resigns on...
What's the date of the Supreme Court's decision?
That's the July 29th.
Right. I may have been back in New Haven, Connecticut. I don't recall that. I was not startled by his resignation. As from that night that the Supreme Court decision, and then I went in the office the next day, I think there was contemplation that he was on. It was not a dramatic moment for me that he would, it was not utterly surprising, but I think I was back in New Haven, Connecticut.
Did you ever talk to Mr. Dorr about the pardon? What he thought of the pardon?
No. I had views about it, but
What did you think of the pardon?
I thought it was kind of betrayal to our commitments about the rule of law. President Ford was invited by the Yale Law School, indeed to get some honor, I think, on that November. I think the pardon had already, when was the pardon issued?
September.
74. He came back in, I believe, early November or late October to receive some medal of something, and I decided not to go to that ceremony. I just thought it was very, I cared too much about law and justice to have that. But I never discussed it with him, and I'm not sure.
After U.S. v. Nixon was decided, did you ever have occasion to talk to either Justice Marshall or Justice Brennan about participating in that case and thinking about that case?
No.
Okay. Well,
I was close to both of them, very close to both of them, and written a lot about them. But I would very rarely, sometimes it'd come up in our conversations when I would see each one over the years, but since I clerked, I never asked them about this decision, that decision.
Did they ever mention to you after the fact anything about, they knew you were working on the impeachment inquiry. Did they ever ask you about that experience? Did you ever? Well, Professor Fiss, have I missed any anecdote or story you would like to preserve? If not, then thank you very much for your time.
Thank you.
You've been most gracious.
I hope it was
Thank
helpful.
you. It was.